Okay, we could probably begin. So tonight we're meant to be talking about natural justice as a topic for the tutorial tonight, but we're giving way, of course, to the group Zoom presentations. And we have two groups presenting tonight. The first one is the AELR group, and then we have the Baron group doing its presentation as well. And may I just request each group doing their presentation to kindly introduce each of the members, introduce the names. And from then on, I leave it to you to begin the presentation. At the same time, I haven't really been provided the PowerPoint slide. So in case you're not very familiar with how to use Zoom, you should be able to find a button there somewhere. And I'm trying to find out where it is now. But there should be a screen which says share screen. And if you click on that, or if you press that, you should then have the chance to actually share your own screen. So in that case, you're able to control your PowerPoint presentation. So
it's currently not letting me because you're currently sharing yours.
Okay, yeah, so I'm gonna get off my share screen presentation now, and then I leave it to Liana to begin the presentation. Thank you very much, Liana, as well as
Thank you.
Everyone else who is here to join the presentation. Okay, let me just see. Okay, thank you. So I give the floor to the AELR group.
Okay, we shall start now. Hello everyone, we are the AELR group consisting of Alexandra Edmonds, Alan Muller, Liana Pritchard and Rebecca Harris. In this presentation, we will be discussing the cancellation of benefits and merits review for DSP decisions. Please refer to slide 3 for the abbreviations we will be using in this presentation. Since March 2010, Mrs. Alice Harvey, aged 22, had been receiving the DSP due to a permanent intellectual impairment, autism. However, following changes to DSP eligibility and requirements in the Australian Government's 2010-11 budget and 2009-10 budget with measures introduced in 2012, in November 2014, Mrs. Harvey was required to undergo another job capacity assessment assessed by a medical professional employed by the DHS. Previous to eligibility changes, it was a requirement to be merely assessed by an appropriately qualified medical practitioner. Such eligibility changes were introduced in the Impairment Tables 2011, which reformed the Social Security Act previous impairment tables. On the 8th of February 2015, it was assessed Mrs. Harvey had a work capacity of 7 to 13 hours per week within the next 2 years and be assigned 10 points under Table 7 of the impairment tables. Table 7 refers to brain function with autism effects. However, on the 20th of June 2015, applying Section 94(1)(a)(b) of the Social Security Act, the DHS cancelled Mrs. Harvey's DSP because her impairment rating was less than 20 points. Mrs. Harvey undertook the following appeal process of the DHS decision. First, with an application for review on the 5th of July 2015 by an authorised review officer who, after an internal review, affirmed the Department of Human Services decision. Mrs. Harvey then sought a review of the ARO's decision in the Social Services and Child Support Division of the AAT. On the 2nd of August 2015, the Social Services and Child Support Division affirmed the DHS decision. Mrs. Harvey contends that she had a permanent intellectual impairment at the date of DSP cancellation, which attracts at least 20 points under Table 7 of the Impairment Tables 2011. A report by Dr. Howard Green, clinical psychologist, on the 12th of August 2015, outlines that Mrs. Harvey has a continuing inability to work or undertake a training activity for 15 hours or more per week during the next 2 years. Regarding permanent intellectual impairment, a condition is only permanent if it has been fully diagnosed, treated, and stabilised by an appropriately qualified medical practitioner. A report by Dr. G.N. Mosley, clinical psychologist, on the 15th of August 2015, outlines that Mrs. Harvey's impairment is fully diagnosed, treated, and stabilised. Please refer to slide 5 for DSP qualification requirements.
Mrs. Harvey's case concerns the cancellation of benefits, with the following issue identified: eligibility to appeal for a merits review to the AAT. An administrative decision that is likely to affect a person's interest should be subject to merits review. Merits review involves a review of a decision based on its merits. It is the reconsideration of a case in regards to the facts and legalisation used by the original decision maker. Merits review is considered as standing in the shoes of the primary decision maker. Under Section 27 of the AAT Act, for a person to have standing to appear before the AAT in a merit review process, the applicant's interests are affected by a decision may apply to the AAT for review of that decision. The objective of merits review is to ensure decisions are correct and preferable. This pertains to the applicant DSP assessment and whether such a decision by the DHS is the correct decision or provides opportunity for a preferable decision to be made. By appealing for a review, it provides an opportunity to discover whether any such decision can be made. A review of the original decision gives opportunity to ensure that all policy guidance provided in 2011 impairment tables and Social Security Act have been correctly applied to the applicant's circumstances and accurately assessed by the appropriate tribunal or regulator. Having the DSP decision reviewed improves the quality and consistency of primary decision makers and ensures the fair treatment for individuals affected by an administrative decision.
From July 1st, 2012, DSP recipients may continue to receive DSP payments if they have a continuing inability to work 15 hours or more per week. However, DSP payments may be cancelled if the recipient no longer meets the impairment or continuing inability to work qualification criteria following the eligibility changes. With relation to the Social Security Act, the DSS and DHS can validly cancel DSP payments, as this Act consigns these organisations the responsibility for the overall administration of the Social Security to people with disabilities or a continuing incapacity to work. However, with reference to the AAT, decisions made by the DSS and DHS are subject to review by the AAT for both the SSCSD and the General Division of the AAT, by parties who have had their interest affected by the decision.
An applicant affected by an adverse decision made by the DHS has, with reference to the Social Security Act 1999, Section 126 and 135, the right to have the original decision first internally reviewed by an authorised review officer who was not involved in the making of the original decision. Furthermore, if this fails to satisfy the claimant, the decision is further available for review by the SSCSD first review and following the AAT General Division second review. Please refer to slide 7, which highlight the process and requirements for an applicant seeking the appeal of a DSP decision. Furthermore, in regards to the review process, merits review allows a wide scope of powers that are outlined in Section 43(1) of the AAT Act. It is established within these powers that the AAT may exercise all the powers and discretions that are conferred by any relevant enactment on the person who made the decision. However, with reference to slide 8, it is highlighted that the merits review scope can only go as far as acts and legislation allow it to. Thank you for listening to our presentation on the topic of cancellation of benefits and merits review for DSP decisions.
Thank you. Well done. Before we get comments or questions from the rest of the class, let me just make some observations. First of all, I've actually had the chance, well, obviously I had to go through what you had submitted in Moodle, the MS Word document. And let me say that I am extremely pleased by the quality of the written work that you submitted. Not only in the way that you presented the factual background, including the relevant legislation, but also the kind of questions that you raised. And so I was actually surprised with the quality of assignments with the submissions that I've seen so far. So well done, AELR. It was really hard. And I'm also very pleased with the Zoom presentation. So you did it really well. Not only, I mean, you obviously came prepared. You were able to also share the workload. And I'm very happy that, you know, each of you was given the opportunity to do the presentation, because doing a presentation is a key skill of a lawyer. So well done. And thank you for really doing well. Now, we leave it to the class to ask questions, make comments as well. Are there questions from the class?
Well, I'll just, can you hear me?
I could hear you, yes.
Excellent. I'll just chuck in a quick, easy question to the team. I'd like to know whether this lady needs to be represented by a solicitor in her AAT tribunal hearing.
Pardon, could you please just repeat the question? I didn't hear you correctly.
Does the lady have to be represented by a solicitor in the AAT hearing?
It is not essential, but it would be required to be represented by a solicitor, so the solicitor is able to more or less persuade and provide the necessary documents and corroborating evidence so that she may be able to prove that she is in fact eligible for the DSP.
Thank you, Tony, for asking the question. Thank you. It was very good.
Fair enough. Yeah, just...
I'd like to give the other students in the class an opportunity to ask questions before I start asking my own question. So we'll give it a few seconds, give it a minute. Okay, so because there aren't other questions, I will be the one asking the questions. And please note that in doing so, my purpose is simply to help us dig deeper into the potential legal issues of the case. Bear in mind that any factual background typically raises several legal issues, and potentially some of these legal issues may not really have been noticed by you in the course of your group deliberations. And so when I ask these questions, therefore, it provides you an opportunity to reflect upon my questions, primarily, at least for the purpose of coming up with an even better individual research essay, because as far as the research essay is concerned, you're meant to identify the legal issues and then the relevant rules, and then apply the relevant rules to the facts. Okay? And so I'll leave it to you to decide who will then be giving the answer. I'm gonna mute everyone right now because I hear a lot of background noise. So if anyone wishes to answer my questions, please unmute yourself. Okay, so let's begin. I actually have about 3 questions here. So the first question is this. Would there have been a requirement for the DSP? Yep, so I think that was the name of the agency, right? So whatever the agency involved was, would there have been a duty on the part of the DSB to inform every single potential recipient? So meaning somebody who hasn't received any benefit yet. Would there have been a requirement for the purpose, for example, of the rules of natural justice, for the DSB to inform every single person who could potentially be a claimant of the benefits that they are unlikely to be entitled to the benefits under the law?
Yes, so it's the Department of Human Services and also the Department of Social Services. So they are the regulators of the disability support pension. And I do believe that when claimants are approaching or trying to get the disability support pension, that they are informed of the certain qualifications that they need to cover to actually get the disability support pension.
So assuming that you have a party, let's say the name of the person is, let's say, Jake. So Jake is thinking of applying for a disability under the law. Now, let's assume that at the time that Jake went to apply for one of the benefits, he was actually turned down and no reason was given for the decision. There was no reason in the decision that was provided to Jake that he was unqualified. So my question is, in that circumstance, so Jake has has just applied. He has not been a recipient of any benefit under the law, but his application was turned down by the DHS and the Department of Social Services, and both agencies, or one of those agencies, did not provide Jake with the reasons for declining his application. My question is, in that case, is there a potential breach? Is there a breach of natural justice?
In that case, I do believe there would be a breach of natural justice due to the fact that the Department of Human Services, if their application has been turned down, the Department of Human Services should be providing reasoning for such turning down. So they should be like referencing relevant Social Security Act sections, which would qualify for the DSP, because Mrs. Harvey qualifies in some sections for the DSP, and when the Department of Human Services cancelled it, they provided a reason for that. So if the Department of Human Services did not provide a reason for that, then I do believe that would be an infringement on natural justice.
Would there be a distinction, as far as the right to natural justice is concerned, between a potential applicant who goes to the AAT, where one is currently receiving benefits, and the benefits were then withdrawn, as opposed to somebody who is interested in receiving benefits, but the application for benefits was turned down by the DHS? I asked that question in relation to the principle of natural justice. Does the principle of natural justice apply in both cases, meaning between one who has been receiving benefits and the benefits are then withdrawn, as opposed to somebody who hasn't been receiving benefits yet and has applied for one and then has been turned down? Would the rules of natural justice apply in both cases?
I would say that the rules do apply in both cases if they're not giving any reasoning behind why they're turned down, whether they are receiving benefits as is or they're applying to have benefits as is, they're entitled to know why.
Mm-hmm. Okay.
And I suppose the question would be, why does one receive it and why does the other not? So it would need to be assessed, would it not, as to why the second person is not eligible. Was that what you mean?
Yeah, that's going to be my second question.
Sorry.
Would there be comments on the rest of the class in relation to the answers that have been provided by the group? Okay, so let me just point out that the principles of natural justice actually would not apply equally in both situations, because the principles of natural justice, primarily, especially in relation to the right to be heard, would only apply if a decision would affect a right, an interest, or a legitimate expectation. So in the case of a person who's applied for a benefit, there is still no right. Neither can that person claim to have a legitimate expectation, because the legitimate expectation can potentially arise only if there might have been a promise or a policy which clearly indicates that that person is potentially entitled to the benefit. So just take note of that. So natural justice arises only if there has been an impairment or an interference with the right that exists. If the right, so in other words, somebody is claiming does not yet have a right. Now, having said that, in relation to Mrs. Harvey, therefore, do you suppose that she is in fact entitled to the right to natural justice, particularly in relation to the right to be heard? So in other words, it would be incumbent for the DHS to inform her of a change in her benefits before the DHS does so. Because if the DHS just unilaterally changes the amount of benefits that Mrs. Harvey will get without informing her, there would potentially be a breach of natural justice. The question is that correct?
I believe that would be correct. She's currently receiving benefits and is under the understanding that she is still able to receive that benefit. She relies on that. They've changed that. She's unaware of this change. I believe that would be a breach of natural justice.
Very good. So
Definitely. Yeah.
That would be correct, because she has a right. Now, so was it Alexandra earlier who asked that question about somebody saying that, oh, I'm exactly in the same situation as Mrs. Harvey. I'm also suffering from a major impairment such as autism. I also know that, I haven't been working, so on and so on. Now, let's assume that when a decision was given in relation to Mrs. Harvey, assuming that it was favorable to her, okay? Now, there is this person who is very familiar with the case of Mrs. Harvey, who, in terms of the circumstances, that person is alleging that they have similar situations. And let's assume that, and that person has also been receiving benefits, just like Mrs. Harvey. That's why they know each other, because they've been comparing notes. Now, let's assume that in relation to that person, the decision has not been favorable. So the second person is claiming they have exactly the same circumstances, but in relation to her, the decision is unfavorable, which makes her wonder, how is that so? When Mrs. Harvey, who has similar circumstances as her, was given a favorable decision. The question I ask is this, and this was the case that I think Alexandra was pointing at. Would it be possible, would it be legally permissible for that other person to cite the decision made by the DHS in relation to Ms. Harvey as a ground to support an internal review, so that the internal review decision should then be equally favorable to that second person?
I'll talk now from a quote by is it all right if I talk?
Sorry.
Sorry, mine was on mute as well.
No, you're right.
Yeah, you go, Liana.
I believe that he or she would be able to provide reasoning via Mrs. Harvey's decision. It is persuasive. There was a quote by Your Honour Gary Downs that past administrative appeals tribunal decisions, they aren't binding upon the courts, but they are persuasive. So he or she, they would be able to provide that to show that, well, my circumstances are similar, and yet Mrs. Harvey has been given a whole different decision to me. So I do believe they'd be able to provide it.
Comments from the others?
Yeah, I agree with that. There's no formal doctrine of precedence when it comes to the tribunals, but it's the same. It's like persuasive and everything in that respect.
But notice that the decision I was speaking of was a decision of the DHS. It wasn't a decision of the AAT. Okay, so which is why I asked, is it possible for that other person to cite a decision of the DHS in relation to Mrs. Harvey to support that other person's claim that he or she should be, let's assume it's a male, that he should be similarly treated as Mrs. Harvey and should therefore receive a favorable decision in the same manner that Mrs. Harvey has gotten one? So that was my question. It wasn't about an AAT decision.
So, sorry, do you mean as if he's applying for DSP and he's using Mrs. Harvey's case?
Yes.
Okay, that's what you mean. Okay. Yes, I would say so. Again, I would say that it obviously is about his eligibility on its own, but I'm sure that, again, he could use it as a, suppose, just a reference to go on and be like, well, this is what it's stated in her case, the eligibility. If it was the same thing, I would think yes. He could use it.
Comments from the others?
I'm not sure that I agree completely with that. I'm a bit torn whether, because he's just simply applying for DSP. I'm confused behind my reasoning, but I just don't feel it like that he should. I know that they are talking and comparing notes about their situations and everything, but that's a completely separate matter when it comes to applying within the department. I don't feel that there's a link. She's not setting a precedent like you would in a tribunal. I feel that that's a completely separate.
Right. So the answer of Rebecca, right?
Yeah.
Okay, thank you. The answer of Rebecca is actually correct. So you will, and so you, sorry, I'm kind of getting confused with the name. So Liana, for example, and I think Alexandra as well pointed out that the decisions of the AAT are not binding on future AAT decisions. And there are actually two main reasons for that. One is that every administrative decision is meant to be in relation to a particular applicant. And because it is in relation to a particular applicant, necessarily we have to assume that every single applicant would have different circumstances. And those circumstances actually constitute facts. Okay? So it's so difficult to say that because, A has been treated this way, then I should be treated this way. Because potentially and most likely, the circumstances won't be the same. But more importantly, the other reason why there's no such thing as stare decisis as far as administrative decisions are concerned is because when the administrative agency and the AAT, for example, arrives at a decision, they're mainly focusing on the facts. Okay, so their decision is based on the factual scenario of every single applicant, as opposed to a decision of a court, meaning a Chapter 3 court, where the decision relies not just on the facts, but actually on the law. So that when a court arrives at a decision, the court actually amplifies and elaborates on the law, and it is actually the law which becomes the basis for the judicial proceeding, not the facts. Okay? And so for that reason, decisions by the AAT, given the fact that factual backgrounds change, can't really become the basis for stare decisis because it's based on the facts and not really an articulation of the law. Okay, very good. Any other questions on the class? So well done, the three of you, Liana, Alexandra, and Rebecca. You did extremely well, and I'm very pleased with the quality of your work. Thank you. Thank you.
Thank you.
Thank you.
Okay, and I'd like now to give the floor to the next group that will be presenting, and that will be the BANJ group or the BANG group. I leave it to the group to turn on their mics and be prepared to share the screen. Oh, hang on, Ellen, were you part of the group as well? Sorry, I didn't mention your name. So well done as well, Ellen. I wonder if I may have missed the other group members, but your group did really well. Okay, thank you.
Okay, hi everyone. We're Group BANG. We're covering the issue of refusal of refugee visas, and we aligned our topic with merit review. Our group consists of Ben, Angie, Grace, and myself. And I'll start with the factual background. Australia is a signatory of the Convention relating to the status of refugees, a system created to protect refugees at the risk of persecution in their home country. The Convention, as amended by the Protocol relating to the status of refugees, is incorporated into Australian law by Section 36(2) of the Migration Act. Due to the increase in visa applications from war-torn countries such as Afghanistan, Iraq, and Syria, on Australia under the Convention and how it fits Australia's humanitarian program. Under the 2014-2015 humanitarian program, the Australian government allocated 13,750 resettling places to refugees with additional...
You're cutting out.
12,000 places for refugees.
Is it cutting out?
In response to the war in Syria and Iraq. Refugee may apply for refugees now. Can you hear me?
You're cutting out.
Cutting out. Am I back now?
Yeah, I think you're good. You're good now.
Good. Refugee may apply for a permanent protection visa in Australia if they meet the criteria set out in Section 36(2) of the Migration Act. Mr. Petros, an Iraqi citizen, came to Australia legally on a student visa after receiving a scholarship from the Iraqi government. After completing his final exams for the year, Mr. Petros returned to Iraq in September 2014. He planned to return to Australia in 2015 to continue his studies. In the first week, Mr. Petros was home. Islamic State fighters came to his house looking for weapons and supplies. While searching the house, they found scholarship documents and foreign language university textbooks. They subsequently threatened to if he did not leave the area now under control of Islamic State due to his Shia faith and involvement with a Western country. Mr. 14, upon his return, he applied to the Australian Department of Immigration for a permanent protection visa. The delegate for the Minister for Immigration refused the application in accordance with Section 65 of the Act. Mr. Petros felt aggrieved as the delegate refused the application on the basis that the information supplied the application was not reliable. Mr. Petros feels the delegate did not consider all resources when reviewing his application and is genuinely concerned for his safety. He has to return to Iraq.
Are you still there, Nicholas? I mean, I couldn't hear anything.
Yes, sorry, I just didn't unmute my phone. Just my mod. Yeah. What recourse is available to Mr. Petros to have the decision of the delegate reviewed? Which route would you recommend and why? A person may appeal the decision to the Administration Appeal Tribunal under Section 25 of the Administration Appeal Tribunal Act 1975 if the legislation the decision was made under allows for it. A person has a standing to appeal to the Administrative Appeal Tribunal under Section 27 of the AATA Act if their rights have been affected by the decision made. The unfavorable decision made by the delegate for the Minister for Immigration can be reviewed under Section 408 of the Migration Act 1958. The review of the decision occurs in the Migration and Refugee Decision of the Tribunal, which has the authority to review the decision in relation to the grant or cancellation of protection visas in some circumstances. The AAT must review the decision under Section 4141 of the Migration Act if a valid application is made.
New information regarding the situation in Iraq has become available since the application was refused. Can this information be taken into account in a review of the decision to refuse the application? An applicant may request a de novo review by the AAT of all material examined by the original decision maker, along with any fresh evidence submitted to determine if the original decision was the correct and preferable one. Section 423A1 of the Migration Act 1958 allows an applicant to raise a claim or present evidence that was not raised or presented in the application before the primary decision was made. Section 423 of the Act allows for an applicant to provide the AAT with a statutory declaration regarding any matter of fact that he wishes the AAT to consider, along with written arguments relating to the issues arising in relation to the original decision under review. Section 43(1) of the Administrative Appeals Tribunal Act 1975 provides the AAT with all powers of the original decision maker and allows the AAT to affirm, vary or set aside the original decision and substitute a new decision.
Mr. Patros has provided the substance of his case to the AAT for review. What is the question to be determined by the AAT on the material before them, and why? The scope of the merit review process by the AAT is not to make a judgment on whether the decision of the original decision maker was right or wrong based on the material available at the time of the original decision. The purpose of the merit review by the AAT is to find the correct or preferable decision based on the material before it at the time of the review. Where the original decision maker has made a discretionary decision, where there are multiple options that would be equally lawful, the AAT would need to exercise its general discretion to find the most preferable decision. Where there is only one lawful determination that can be made based on the material available at the time of the review, the AAT would aim to arrive at only the correct decision. Parties appearing before the AAT should not present an argument that the original decision was wrong, but rather should be presenting an argument that there is a more preferable or correct decision to be made based on the material currently available. Thank you. That's our presentation.
Thank you. So you've all spoken, right? So we've got Nicholas, Grace, then Anjanette, and Benjamin. So again, let me give a general feedback first on your assignment. So after having gone through the written submission in the MS Word document, again, I'd like to say that I am very, very pleased with the quality of the submission. So the way that the factual background was stated was well written. It provided a very compelling and very interesting case, and was able to highlight the relevant legislation that would affect the decision of in relation to Mr. Patros. And the quality of the questions as well were quite provocative, and were actually meant to really force readers to think about their potential answers. So again, let me say that the group did really well as far as the submitted MS Word document is concerned. So well done, Bank Group. In relation to the Zoom presentation, again, I'm very pleased with the quality of the presentation. You obviously came in very well prepared, and I've seen the relevant PowerPoint slides that were shown in the course of the Zoom presentation. And it also was clear that you had really prepared for the Zoom presentation. So again, well done. Well done, Bank Group. Now, having said that, so well done. Having said that, we're again going to open the floor to questions or comments from the class, and then I will then come up with my own questions. But in the meantime, I'd like to provide the rest of the class an opportunity to ask questions to the group. And I'm going to mute everyone because I'm hearing some background noise. And if you want to say something, just unmute yourself. So comments. So please feel free to ask any question or raise a comment. We'll give it a few seconds. And who was that? Ben. No, sorry.
That's Tony.
Thank you, Tony.
Can you hear me?
I could.
Ah, yes. I'm just going to throw in my usual straightforward and easy question. When Mr. Petros puts in his application to the AAT for the review of the decision, what fee will they charge him? How much does he have to pay the AAT to file the review?
I could look it up. I don't have the fee offhand.
Okay, well, it's free. This particular one just happens to be free. That's all. It's one of the few that are no cost, because he shouldn't have any money anyway as a refugee.
Thank you, Tony, for that information. Actually, I didn't know that.
I think that I found some of the information that the fee is $1,650, but I'm not sure whether it's correct one. That's what I found it. So
It's free. I looked it up. It is. It's one of the couple that are actually free. It's on the AAT website fees page.
Okay, thank you, Tony.
But the others are up there in that region. Yes.
Thank you, Tony. Questions from the other members of the class? Okay, so let me throw in some questions. In the case of Mr. Patros, I wasn't too sure if a decision had been provided by the immigration minister's delegate. Hang on. Was there a decision that was given? Oh, I mean, was a decision made in relation to Mr. Patros? I can't remember the facts clearly. Not your fault, my fault. So was a decision given?
Decision made to refuse the application.
Okay. Yeah, so I missed that fact. Okay, so my question is, in relation to that decision that was adverse to Mr. Patros, would there have been a requirement to give Mr. Patros reasons or a reason for the denial of his application? Would there have been a requirement, a legal requirement, for the minister's delegate to provide a reason or reasons for the denial of the application of Mr. Patros to become a permanent resident?
Yes, I think there are. I think there's a requirement. I don't know the section that.
Okay, so let me just clarify a bit. Assuming it is not in the law, so it's not in the legislation. Let's assume it is not in the legislation. The question is, would there be a common law right on the part of Mr. Patros to expect reasons to be provided when a decision was made against him?
Under natural justice, natural fairness protocol, Mr. Patros should expect the reasons why his application should be given. The reason should be given to Mr. Patros why his application was unsuccessful.
Mm-hmm. Comments on the others?
The department provided decision notification letter to all applicants, and I think in that they should provide the reasons and also a time frame if they have a choice of whether or not to have an appeal against the decision.
Okay, so again, because obviously if the legislation says that the minister has to provide reasons, or the minister's delegate has to provide reasons, then obviously then the minister's delegate has to provide reasons. So my question is, assuming that the legislation did not specifically provide for that, my question really is, would there be a right on the part of Mr. Patros, as part of his presumed right to natural justice, to be provided reasons for the denial of his application for permanent residency? That is my question, because if you assume that he has a right to be provided reasons, then we can argue that there has been a breach of the right to natural justice. So that is the nature of my question. Let's assume for the moment that it is not in the law, meaning not in the written law.
I would think if he's put in an application, he has the right to know the reason why it's been rejected.
Mm-hmm.
So that he's got some sort of I don't know, some sort of reason for appealing. You know, I mean, he's got to have a reason to appeal, hasn't he? So he would have to have the right to know why it's been denied.
Mm. Okay, I'm setting aside my question because I'd like to follow through what you said, Anjanette. You said that Mr. Patros needed to know the reasons, because otherwise, what arguments will he bring before the AAT? Is that really a correct approach? Meaning, is the AAT actually meant to review an administrative decision on the basis of whatever was said by the initial decision maker? Or is it possible, therefore, for the AAT to review a decision de novo, even in the absence of any prior reasoning given by the original decision maker? So in other words, if the latter case is correct, then it shouldn't have to matter whether or not decisions or reasons were actually provided in the original decision.
Mm.
The other group members, what do you think? Or the rest of the class?
Yeah, yeah.
I think that oh, sorry.
Okay.
Yeah. Go ahead, Tony.
Tony, yes, please.
Okay. Yeah, just in my opinion, that they only have to give a decision, and they have to give that decision in writing, because that's the thing that starts the time clock for the appeal process, and there are different time limits applied to different types of decisions. But you've got to have a decision. They ought to give reasons, but I don't think they're compelled to.
And if
you don't need them, you don't need them for the AAT. No, you just need the decision, in my opinion.
That would be correct.
Corrected.
Tony would be correct. Again, remember that the principle of natural justice, which is a common law right. So when you speak of a common law right, it is a right recognized by the courts. Okay? Mm-hmm. So the principle of natural justice, or the rule of natural justice, arises only when an aggrieved is able to say that his right, his interest, or legitimate expectation has been impaired by a decision of an administrative decision maker. In this case, Mr. Patros cannot claim to have a right to become a permanent resident. That's exactly the reason why he has applied in the first place. Now, it would have been different if he had been granted permanent residency and then that was revoked. That is a different situation. That will certainly require the principle of natural justice to be applied. But to an applicant, in relation to the Minister of Immigration, there is no right to natural justice, particularly in relation to needing reasons. Okay, now, but Tony raised an interesting point. He said that, and so Tony was correct in saying that there was really no requirement unless the legislation provided for it. In the scenario I gave, we don't really know what the legislation is saying. In fact, we're saying that the legislation did not provide a requirement of natural justice to be observed. But Tony correctly pointed out, so initially Tony correctly pointed out that there was really no need for decisions to be given, and in that, I mean, reasons to be given, and in that case, there is no breach of natural justice. But Tony did point out that there would have been a requirement for a written decision, because that written decision flags or triggers, especially the timelines, the regulatory periods during which potential appeals or applications to the AAT can be made. The question is this: is that correct? In other words, first question, if there is no written decision, then there is a breach of natural justice. Is that correct?
I believe so.
And secondly, in other words, is there a requirement that every decision maker must come up with a written decision? And secondly, assuming that a decision maker does not come up with a written decision, would it mean, therefore, that no decision has been made because a written decision was not given?
There is this issue is that a lot of the decisions don't have time limits applied to them. And there's this one about the refugee centre in Nauru or something. They're having a case over it, and I don't remember the details of it. But they haven't made a decision, and they've put off making a decision for something like years, and nobody can force them to make a decision. So the thing is still open, so nobody can review it because they haven't made a decision, and they haven't made a decision because they don't want to be politically incorrect. So it's that sort of catch-22 thing. And in reality, they should be forced to make a decision, and that would be a natural justice thing, and you could probably go to some humanitarian court and say, look, we need a decision because people are dying. But anyway, that's just an extra bit on there.
Very good. Thank you for the comment, Tony. Comments from the group before I respond to what Tony has said in elaboration of the principles involved.
Just make a comment that the Migration Act states in a section 422B that this division is taken to be an exhaustive statement of the requirements of the natural justice hearing rule in relations to the matters dealt with. So I think that the Migration Act states clearly that there should be adherence to the natural justice while dealing with the applications for the protection visa.
Okay, but again, I said initially that the scenario I gave was that we assume that the legislation did not provide for the rules of natural justice to be followed. So that was the nature of my question. Okay, now let's see. So going back to the point of Tony, which is really provocative, so that the idea that if there is no written decision, that there is a potential breach of natural justice because there seems to be a requirement as far as natural justice is concerned that a decision of an administrative decision maker has to be in writing, so that in the absence of a decision in writing, there is a breach of natural justice. My question really is that correct? Now, if we recall, as far, for example, as the Administrative Decisions Judicial Review Act of 1977 is concerned, one of the ways by which an application for judicial review under the ADJR Act 1977 is concerned can be made is in relation to decisions not having been made. So in other words, if you make an application with an administrative decision maker and the administrative decision maker does not make a decision, the question is, does that mean there is no decision?
Well, there wouldn't be a decision, would there? And it'd be much like Tony said, it would just go on and on and on. Therefore, there's a natural, a natural justice problem there then, isn't there? Because there hasn't been any decision made and that person's just sitting there waiting and waiting to find out if their application's been approved.
So that is exactly why the ADJR Act provides that even the failure to make a decision can be subject to judicial review. So in other words, the failure to make a decision is in itself a decision, which is subject to the judicial review. So let's clarify that. So if a decision maker fails to make a decision, that can in fact be the basis for judicial review. Okay, so that should be clarified. No, there is no. Yes, Tony.
Sorry, I was just saying. Well, how does that fit with the fact that there is no time limit in the Act that says when they have to make a decision? The average time it takes to go through the AAT is about 400 days before you get through the process and get a decision. That's if you get a decision.
That's
and
right.
There's some things that have gone to the AAT that have been outstanding for years.
You're very correct.
So when do you decide that there hasn't been a decision?
You're very correct.
Yeah. So you've got this catch-22 again, haven't you?
That's right. So Tony is correct again in saying that it's difficult to say when a decision really has not been made. So at the end of the day, it's really for the courts to determine, and it's really for the lawyer to plead the case that a decision should have been forthcoming at a certain point. I was just flagging the fact that it is under the ADJR Act that the failure to make a decision is in fact a ground for judicial review under the Administrative Decision Judicial Review Act. Now, whether or not a specific case can actually be argued to justify an application for judicial review on the basis that a decision had not been made really ultimately depends on the individual facts of the case. So the example given by Tony is really relevant. So there will be instances when, you know, the immigration minister may purposely delay the giving of a decision, and especially if there is no time frame within which a decision has to be made, then it's difficult to argue that there has been a breach of the specific legislation. Okay. Questions, comments? No, there was something about being forced to make a decision. Yeah. Was there a requirement, assuming that it is not in the legislation? I think it was Tony who referred to this. Assuming that there is nothing in the legislation which says that a decision maker has to make a decision within a particular time frame, is there a duty on the part of a decision maker to make a decision within a certain period of time? And if there is a delay in the decision making, therefore, there would be a breach of natural justice. No, the answer is no. Very good. Very good.
Manjo, just on that, like, sort of, given that merit review is meant to be, you know, it's meant to be like informal and cheaper and, you know, sort of all those sort of things, wouldn't it be in their best interest to give a decision as quick as they possibly could anyway, even though there's nothing in legislation that may say a decision has to be given by X amount of days or weeks or years? If in the interest of sort of keeping in line with that it's informal and it's meant to be cheaper and that yeah, just sort of give the decision as soon as you can, I suppose.
Let's make a distinction. I think you're referring, Tamara, this time to a decision of the AAT. There is an expectation, in fact, of the AAT to make a decision within a time frame. The question we were dealing with was in relation to a decision by the original decision maker. The question was, is there a requirement, assuming it is not in the legislation, is there a requirement on the part of the original decision maker to have to make a decision within a specific time frame? That is a question. And the answer is no. In the absence of legislation, there is no requirement that a decision has to be made within a certain time frame. The AAT certainly, yes.
So why would a decision maker not have to be sort of to not be kept under a time frame? Like why should they be allowed to sort of take as long as they like, if at all, and yet somebody like a review tribunal has to be under a time limit?
The first answer to that question is that it's really a policy decision on the part of the Commonwealth Religious Parliament. So it's up to the Commonwealth Parliament to determine. It is not a right on the part of any member of society to expect that every decision maker has to make a decision within a certain time frame. That is a statutory right which the Commonwealth Parliament makes. The Commonwealth Parliament does not provide a statutory requirement that a decision has to be made by a decision maker within a certain period of time, then there is no such right. So the simple answer to that is it is up to the Commonwealth Parliament. And certainly because of that, there is nothing that compels the Commonwealth Parliament to have to provide a right on every member of society to expect to be given a decision within a certain time frame. Again, that's a policy decision on the part of the Commonwealth Parliament, which cannot be controlled by the courts.
Okay, thank you.
Okay, yes, questions from anyone else?
Manjo, I would like to ask a question. What
Grace, yes.
If there are some departmental policies that they might put the time framework for the appeals, because sometimes we've got the statutes, we've got the legislations, but also some departments create their own policies and they are binding, and they could be having the time limitation. Because I think I read one case when in one of those policies, departmental policies, that was a time limit 3 months and the person did not get the answer within 3 months' time, and that was the grounds to appeal, to have a judicial review of the not having a decision, what you were saying, but that was based on a policy grounds, not on a statute.
Very good. So you're actually correct, Grace. Now, in relation to the regulation that was created or drafted by the particular agency, that is actually considered part of the legislative framework, because it is known as a subordinate legislation, or it's delegated legislation. So in that case, because it is one of the requirements in the regulation, there therefore arises a right on the part of an applicant for the agency to decide within that time frame. So in that case, therefore, the right to be given for a decision to be made within a certain time frame can emanate either from primary legislation passed by the Commonwealth Parliament or from subordinate legislation passed by the administrative or executive agency itself. So you're correct on that point. Okay, so thank you everyone. It's now past 7, and so we've gone beyond our time for tonight's tutorial. Thank you very much for engaging at tonight's session, and in particular, I want to thank Tony for asking a lot of very, very provocative questions and providing a lot of information that was important to us. And again, also to Tamara, thank you, and well done to the two groups and to the group members. You did really well. Okay, so I'm hoping that the future groups will be able to deliver the same kind of performance as the two groups. And yeah, having said that, Happy New Year, and I hope to see you again next week. Good night. Bye.
Bye-bye. Bye-bye.
Bye-bye.